Okay, let's get started. Good morning, everyone. We're so excited to have you here. Welcome, Notary Academy students. We have Sandra Piper from Secretary of State here with us this morning. Woo, woo, woo. Thank you, Sandra.
Sure.
We're all excited to have you. Sandra is a compliance analyst with Secretary of State, and I will let her introduce herself for a few minutes. We'll go over questions, and then if we have time afterwards, we'll do a little Q&A. So thank you, Sandra.
Sure. Okay, so yes, my name is Sandra Piper, and I am a compliance analyst with the Secretary of State in the Notary Public section. And just a little background, I've worked for Secretary of State now for a little over 33 years. I've specifically been a notary for close to 18 now. The last 2 years I've spent in the compliance unit, which is kind of a revamped unit of the investigations area. So this is my first type of Zoom call like this. I know Cynthia, who was here before, did the majority of these, and so we'll just kind of plug through it and see what we can answer. Even though I've been here a long time, I will tell you that it never ceases to amaze me that there's always things that come up that we've never heard of before, and that we will have to do a little bit of research in. So if any of those things come up during this meeting, I have my notebook here and I will write it down, and I will research it and get back to you. So we'll see if that happens, but I can definitely do that if there's something I'm not 100% sure about. So I do have, I believe one of my coworkers, Jamie Lee, is on the line. She's going to be listening in. She's fairly new to the compliance unit, and so I wanted to kind of listen in and see how this all goes. And I invited another one, Amy. I don't know if she's here yet or not, but she may join us at some point soon. She's actually working in the office today, so she might get pulled away occasionally. But other than that, I don't know if you have any questions for me right off the bat as far as my position and what I do or anything. But I guess just to give you just a quick rundown on the compliance unit, we used to have what we call peace officers or actual law enforcement investigators that worked in notary. And a couple of years ago, because most of the notarial cases are all mostly admin cases, we don't really handle criminal type cases in notary. It's all admin. So they kind of revamped, because it took so long to hire actual investigators. They revamped the unit and changed it to the compliance unit. And we have compliance analysts doing the investigations right now. And it's mostly for notarial misconduct. If we do come across a criminal case, we also have actual investigators in our elections unit that can help us with those. The majority of them that do come through are actually handled by the county law enforcement in the county where it took place. So on our end, we can revoke and assess fines in an administrative action, but as far as criminal convictions, that's normally handled with law enforcement or the DA's office in that county. So that's kind of how the compliance unit came to be. And it's just kind of revolving a little bit, I'm sure as time goes on, they may change duties a little bit, add things, take things away. I don't know. But for right now, we're kind of getting into that groove, and we're doing pretty good. There's 3 of us, myself, Amy, and Jamie. And so I've been there since the start of the unit, but Amy and Jamie have come on a little bit later. So, and one of them will probably be your contact in the future, because I am retiring at the end of this year. So that's kind of why they wanted to listen in, to just kind of see how one of these works. So
that's great. We love to have them here.
And Sandra, can I ask you just really quickly, so the compliance department, would you say that you're dealing more with basically notaries being fined for negligence?
Yeah, we handle quite a bit of different types. In in the statute here, I think it's 8214.1. Let me find it real quick. Basically, what we do is we'll get complaints in. We'll have people file complaints against a notary for, usually it's for misconduct or what they perceive to be misconduct. And we open a case, we review them and see if it's something that is within our purview and that we can investigate. And then if it's determined that we can't, we just let them know that and we close the case. If it's something we definitely will investigate, then it's opened and it's assigned to one of the three of us and we investigate it. And the majority of the time, I would say the biggest misconduct type things we see are journal violations, notaries filling out certificates that are not factually accurate. So those are probably the biggest things. We've had a few cases where we've had notaries that just fail to respond to us at all. So we will revoke based on non-response. But definitely the most common is going to be the negligence. And then it really depends on the degree of it. Sometimes we'll just admonish the notary and just maybe do an audit later on. But sometimes if it's egregious enough, we will revoke and fine. So does that answer the question?
And so I think we're also curious now that what's been happening, but I think maybe we'll save that for the Q&A. I think everybody wants to know, yeah, what a notary does for that. But yeah, so why don't we go ahead and start the why don't we start the questions, and then I think we would all love to go revisit that after the questions for sure. So, all right, so we'll get started. I'll just read the question, Sandra, and then you'll let us know. So number one, we had corrections to our notarial certs. When is it okay to correct a certificate? May we run to escrow and stamp a cert if we forget to stamp? May we send in certs to escrow if we dated them incorrectly or made a minor error that does not involve the signers? Are there any exceptions for corrections, or must we always notarize with a new date?
Okay, well, this is a common it's a common question. And I guess my answer is you can never correct a certificate. Now, what I will say is if you're notarizing a document and the person leaves the office and realizes out in the parking lot that, oh, they didn't stamp the seal, they run back in, you can stamp the seal. There's not really a problem with that, because really, honestly, I don't really think anybody's going to really know other than that. But actual correcting at a later date there's no provision in the law to allow that, and it really just needs to be renotarized. I don't know any other way to put that. I know they talk a little bit about it in the handbook. There's no provisions for correcting a notarial act once it's completed. But like I said, if it's a small correction, same day, I don't really see a problem with that. But any other, correcting a date or something like that is really not allowed. No.
Okay.
We've had a few instances. I'll just give you just a real quick scenario of a case I had this last year, where we had a notary that had notarized a power of attorney in a hospital for somebody. The document that she was given had a pre-printed notarial acknowledgement on it. It was not the correct language. She notarized it, realizing later that she shouldn't have. She should have used like an attachment on the acknowledgement. So when they tried to file it with the county wouldn't take it. They went back to the notary and they wanted her to redo it, but backdate it back to the date that she did it. And they called me and tried to get me to tell her to do it. And I told her, no, if she's not going to do it. She's not supposed to do it, even though she made the error of not using the right language or not noticing that there was the right language. She didn't want to further get herself in trouble and actually re-notarize and backdate it. She did offer to re-notarize it, but you know, that's where that stood. So, and that was a case where, you know, definitely trying to correct that is it's just a matter of re-notarizing it.
Okay. And just to follow up on that, what would happen if a notary did backdate and send in a new acknowledgement that was compliant and then they got caught? I mean, what's the repercussions for that?
Well, that would be filling out a false certificate.
Mhm.
And that is a grounds for revoking, and that would be a $1,500 fine for a false certificate. So if during an investigation we find out that somebody did that, that definitely would be cause for revoking. That could happen, yes.
Okay. Okay, I think we've answered that question. Next question. Number 2, pronouns. NNA is teaching notaries not to cross out pronouns, but there are a few counties like Sacramento County that still would like us to line through the unused pronouns. What does the Secretary of State say regarding the pronouns for the cert?
Okay, so with pronouns, now when we get documents in for authentication, because we authenticate notaries with the apostilles to go to other countries, we will authenticate it either way. So if they've lined out pronouns or if they've not lined out pronouns, it's not an issue for us anyway. Now, what I will say though is NNA, I guess, maybe they've had some experience with documents maybe not being accepted, but it really is going to depend on the receiving entity for that document. So for instance, if you're going to be filing at the county and they prefer to have it lined through, then you should do that. If you know they're not going to care, then it doesn't matter either way. But it's really probably up to the person that's actually signing the document to find out from the receiving entity what they're going to accept.
Okay. Okay.
So like I said, for us, it doesn't matter if you do or don't, we're going to authenticate it anyway. But the receiving entity, if it's going to be filed at a different agency, then that's where you would probably want to find out ahead of time which way they're going to accept it or if they care at all. So
okay, great. All right, number 3. So for out-of-state IDs, are we still allowed to use these if expired within the 5 years, or is this for California IDs only?
okay, I'm going to get out my handbook here because make sure. I think it's for any ID as long as it's been issued. Let's see, expired. Hold on a second. I thought I flagged this page here. Okay, so Civil Code section 1185 talks about any form, let's see here, reasonable reliance on the presentation of any of the following, provided the document specified is current or has been issued within 5 years. A driver's license issued by a state other than California. So I would say that the IDs, according to what the code says, for out-of-state IDs, it would be the same as the California IDs.
Great.
So they would have to be current or issued within the last 5 years. So that's going to be with any ID. So if you have a driver's license for California or a driver's license for, say, Nevada, it's going to be the same.
Now, what about for passports? Are we allowed to use any expired passports within an amount of time, or is that not the same?
Passports, I think. Yeah, the passports are listed under the first part of 1185, and it, let's see, reasonable reliance on the presentation any one of the following. A passport issued by the Department of State. It says the same thing. Reasonable reliance on the presentation if it is current or has been issued within 5 years. So generally, I think passports are good for 10 years. So if it's past that 5-year mark, that's when it was issued, but it's still good for another 5 years, it's just as long as it hasn't expired yet.
Okay.
Then you can take the passports too.
Okay. All right, great. All right. Next, Patriot Act and the ID forms. Are we allowed to write notary public on these forms as our title, or must we write signing agent after our name on ID forms since we're not notarizing?
Okay, so we did touch upon this at the very beginning, I think before everyone came on.
Mhm.
And the law is very clear on what you can use your seal and title of notary public for. I was just actually pulling up the code here. 82, I think it's 8207. Okay, so Government Code 8207, it talks about a notary public. Let's see. Maybe it's 8205. I'm sorry. I have
That's
all
okay.
these tabs. It's my handbook is, it's all marked up and everything because we use it so much. Basically, the current law states, I'm looking for the actual code section, but basically the law states that you cannot, or notarial statutes say that you cannot use your seal, signature, or title notary public for anything other than providing notarial services. So if you're signing a document where you're not notarizing the document, then you definitely do not want to use your title notary public. You're going to want to use something else. So if you're want to use signing agent is fine, or if you have some other title within your organization that you can refer to, that's okay, but you definitely don't want to put the notary public as a title if you're not notarizing that particular document.
Okay. So that answers questions, everyone. So on Patriot Acts, ID forms, any of those statements, you have to write signing agent, not notary public.
Yeah, and anyway, I just found it. So it's Government Code 8207. There's a paragraph in that statute that says a notary public shall not use the official notarial seal or use the title notary public except for the purpose of rendering notarial service. So it is in the statute, Government Code 8207.
Okay. And Brandy, I think notary signing agent is fine. It's just not notary public. Okay. Satisfactory evidence. So there's a lot of gray area. We have quite a few married names on docs, but ID still shows her maiden name. If the signer has started her legal name change, she has a new social security card with her new married name, and we are comfortable she is the name on the docs, the new married name, may we proceed with the social security card and current ID and have her sign her married name, or does she need updated driver's license with her married name?
Yeah, that is definitely a gray area.
Yeah.
What I normally tell people, because we do get calls from notaries saying, hey, I'm doing a notarization right now, and they have this and this as their ID, they have a new last name. And what I tell people normally is it's really, you really should, if you're not 100% sure it's the same person, you really should make sure that you have an actual ID that falls within the statute, which is Civil Code 1185, with the name on it. Now, we do have instances of what you said here in your question, where somebody just recently got married, they have their driver's license, then they have a marriage certificate that shows the maiden name, the new name. If your comfort level is you're certain that they are the same person, I would say you can go ahead and do it, but I would also note that in your journal somewhere.
Mhm.
Sometimes there's a little spot for additional information in your journal, and just note it that, signer provided driver's license with maiden name on it, also had marriage certificate or whatever it is that you're looking at, or social security card or whatever. But just make sure that you're at least entering one ID that is acceptable with 1185. So if you have the driver's license with the previous name on it, that's what you wanted to put in there. And then if you use something else, like a marriage certificate or a social security card, just note that in your journal.
Okay.
Okay. So yeah, best practices is, if you're not 100% sure, you're going to need to get they're going to need to present the appropriate identification. But again, if you're sure and you feel comfortable with it, and as long as you're notating that in your journal, then I think it's fine.
Now, can we extend that to the paper extension at the DMV?
And they're presenting that with their current driver's
So
license.
let's say it's a different situation. Their driver's license expired. It's past the 5 years of issue date. A lot of signers want us to use the paper extension from the DMV that they've applied for a new driver's license. DMV sends that paper, but they don't actually have their license yet.
Okay, I would say in that case, as long as they have the driver's license that's recently expired, along with that paper, that would be fine.
Okay.
That way you can compare it, you can make sure the numbers match, the names match, all of that. And I think that would be sufficient. And then just, of course, note that in your journal.
Okay, great. Good to know. Okay, so I think that answers number 7 as well. If the driver's license has an incorrect name or an error, as long as we use satisfactory evidence, other ID, birth certificate, social security card to show the correct name, we're okay to proceed. Is that right?
Correct, yeah.
Okay.
And like I said, just make sure you note it in your journal, and that you're at least that you're entering their driver's license number and all that pertinent information in the journal, along with the extra stuff that you looked at. Yeah.
Okay, great. All right, next, credible witnesses. If names on docs do not match the name on the ID, are we allowed to use credible witnesses to prove that name?
Oh, credible witnesses, huh?
So we're having a lot of instances where the borrowers do have current ID, but maybe the name doesn't match on the docs. And so notaries are told, being pushed, well, just use credible witnesses, it's fine.
Okay, so we're talking about like loan type documents.
Correct. It's
And
usually loan documents. And so we've always been told that you can only use credible witnesses if they have no ID or it's expired, because you also have to place them under oath that, their signer that they're verifying their ID has no ID. But sometimes we call the NNA and they tell us it's fine, just use credible witnesses, even if they have current ID in front of them, but the names don't match.
yeah, I would say that you can use the credible witness, because when they're saying they don't have ID, they don't have the appropriate ID. So because if the name's different, they don't have an ID that matches what they're signing. And I think in that case, that's probably correct, that you can use the credible witness. Because I know that like they're certifying or saying that, or under oath, that they don't have ID, which they actually don't have ID that matches what they're signing. So even though they have an identification, it's not matching the document. So the credible witness, I think, would be fine in that case.
Okay. Okay, the journal, here we go. So I know there's a lot of debate on, do we have to use one line per notarized signature per person? Or we've also been told by someone at the Secretary of State that as long as we use the modern journal, we check all the boxes, everything is there, we could do one line per signing or per person. So
Mhm.
what do you say on that one?
So when you're referring to a modern journal,
Mhm.
you're talking about the ones that have all those little check boxes kind of on the left side, and
Mhm.
you can check acknowledgement or jurat, and then it has all these different named documents to the right of
Yep.
it, right? Okay.
Mhm.
Okay, yes, we do see those often. Those come through our office when we're auditing journals quite often. And that's something that we have debated about for quite some time.
Mhm.
I think when I'm auditing, and I'm just speaking from my experience as a compliance analyst, when I do an audit of a journal and I'm looking through it and I see that type of journal with all of those things, I am checking to see, how many docs they're putting on one line. So for instance, if they're all listed individually in those check boxes, then normally that I've been letting those go. The problem is I've seen when I'm auditing journals a lot of times where we'll see when they put a description of what they're doing, they just put loan docs,
Mhm.
and then that's it. So we don't know how many documents there were. We don't know what they were. Sometimes people will put in a lump sum fee, which really is not appropriate either. So I think that's where it gets a little confusing and not accurately done. If you're checking each box and you have each document listed there, and then like if, for instance, say there's 5 documents and they're all listed there, and you go over to your fees section and you can put 5 times 15. So you're differentiating, you didn't charge one lump sum, but you're charged 15 for each doc. I think that's fine. The only thing to keep in mind when you're doing that though is when people say request a line item from a journal for a specific document, if that specific document falls in that line item out of say those 5 documents, you're going to be providing the line item for everything
Mhm.
because you don't have them separated. So just keep that in mind.
Right.
They're probably going to get more information than they're really asking for,
Okay.
but that's your call on that if you don't care. I think that's fine.
Okay. I think we're all really excited about that one.
Yeah.
So as
So
long as we're using the modern journal, we're
mhm,
very accurate and thorough with all of the
mhm,
documents, and our fees. It's okay.
correct.
Okay,
Yeah.
great.
I think too, when you're doing that as well, if you have a document, because I've seen this a lot when I'm auditing journals that are more the modern kind. A lot of times people will, there's a other down kind of the last one on the list,
Mhm.
and they'll mark like acknowledgement for other, but they don't put on there what the other was.
Okay,
So if there's an extra document in there that's not covered on that list and you mark other, you need to make sure that you're putting in that box the additional information, what the other document was.
okay.
Because I've seen that quite a bit where they just don't tell us. It was some other document not including on the list, but it doesn't tell us what the document was. So I think
As long as
that's
everything is labeled.
correct, right?
Okay,
And then also, again, with your fees, when you're doing that, you need to make sure you differentiate. So, if you're doing 3 documents and you write a fee of $45, that's really not correct. You want to make sure that you're putting in there 3 times 15, because when you do an audit, you need to make sure that, you're not, it doesn't appear that you're overcharging somebody. So just keep that in mind as well.
okay. Good to know. I'm going to write that down. Costs. Accurate. So
And
3.
another thing too, just as a side note on the fees, and we get it a lot when we're auditing, is people, notaries just don't fill out the fee box.
Mhm.
And I tell them if they'll tell me, well, because I don't charge a fee, or for whatever reason. And I said, okay, then what you need to do, you need to either line it out or put a 0. Because if you leave it blank, then that's something that's going to ding you on a journal audit, is that you're leaving it blank. So if you put a line through it or put a 0, we'll just know that you opted not to charge a fee for that particular one.
Okay.
And that wouldn't go on, go on the list of issues when we're auditing. So.
Okay. Okay. I guess that was it. We went through that really quickly. And then the last question I had is, what happens to notaries that notarize incorrectly, which we were going to touch base with anyway. So what are some of the common mistakes that you see? And then what are the repercussions, I guess?
Okay. Well, I think there's a number of common reasons why we end up revoking or fining notaries. Not all of them have to do with notarizing incorrectly, but a good portion of them do. So some of the biggest things are the journal violations, where they aren't filling in things, they're leaving things blank. They're accepting IDs that are not allowed. Things like that. Let's see, I'm just reading the question again here. So notarizing incorrectly, right, would be filling out the wrong kind of certificates. For instance, ones that are not worded correctly according to statute, either with a jurat or acknowledgement. Not IDing properly, accepting the right types of ID. Filling out your journal correctly. All of those things are things that we can take action for. And again, those are, I think, the most common things that we will revoke for are what we refer to in our office is a D and an L. A D is in the code 8214.1D. That's the failure to discharge your duties as required. And that's stuff like not filling out your journal correctly, not IDing properly, filling out certificates that don't have the right language. So those are revocable offenses, and you can be revoked and fined. Usually it's a negligent violation of D, which is $750 penalty. There's
So
other
do notaries
things.
typically lose their commission or just get fined? Or both?
It depends. Usually if it's a one-time thing where, say, we're just doing a journal audit, a sporadic journal audit, and we see that they're not filling out their journal correctly, we normally will, or we have a document come through for authentication where we notice that the language is not proper on the certificate. Usually for a 1 or 2 time offense, we will generally send out what we call an admonishment letter. And it's a letter to the notary letting them know that this was discovered during the audit of your journal. These are what the violations are. And you'll need to exercise greater care in your duties in the future. Same thing with authentications that come through where they filled out a incorrectly worded certificate. We generally, on a first time offense like that, we will send another admonishment letter saying by statute you need to use the correct wording. If in the future we do a future audit or we see more documents come through the office that are not notarized correctly, then at that point we do have the option to open a case and you can be revoked and fined. Sometimes I know in the past they've done like a 6-month suspension. Those don't happen very often. It's really up to our manager when he's reviewing our cases if they want to do a suspension, but the majority of the time it's going to be a revocation with the $750 penalty. I was going to think of other things that we can revoke and fine for, just that we see a lot of, are if we get a complaint and we send a certified letter. Generally, when we do get a complaint and we're contacting the notary regarding the complaint, all of those are sent out certified mail to the address we have on record. It is the duty of a notary to respond to us, and we quite often don't get responses. And if that's the case, they will revoke and fine for non-response. Other big things that we see is address changes. Statute says that you are required to notify us of an address change within 30 days, either your business or residence. A lot of times during the course of investigations, we find out that a notary has moved many, many months ago and they never notified us. So if their case goes to a revocation, that is something that we are going to include as part of the violation, is not letting us know about an address change. A lot of times we're not going to revoke for just that. We will ask them to fill out a name or an address change form and send it in to us immediately. But again, if there's other violations and there's enough there that really warrants a revocation and fining, that is something they will include. So those, I think, are the biggest things. A couple other things. Well, I think probably as far as the L, like I said, a D and an L are the most common. L's are filling out false certificates. So the most common reasons for that, we get notaries that are talked into filling out a certificate when the person isn't actually there. Maybe they just talked to them on the phone, or they did they have somebody, a family member comes in with their ID or whatever, and you'll be surprised to know that there are a lot of notaries that actually do that. And that is a no-no. You need to have that personal appearance, and those are revoked with a $1,500 fine if we have sufficient evidence to show that. So anyway, so those are the things that can happen to a notary for any kind of notarial misconduct, notarizing incorrectly, journal violations, all of those kinds of things. So I don't know if I covered everything. If I didn't, let me know, but those are the main things.
Okay, I think that was all good to know. And it's hard to imagine that a notary would notarize without someone in front of them.
Yeah, like I said, it amazes me sometimes, some of the scenarios we get, and especially for if you have a new notary that's only during their first commission, we tend to maybe be more understanding of that, depending on the circumstances, and just warn them not to do it again. But it really depends on the situation. If there was a fraudulent certificate filled out that costed somebody a bunch of money or some property or something, we are not going to be very understanding of that, even for a first-time notary. That's what the notary education is for. You should really be up on those statutes for that kind of thing, because those are serious offenses. Right. What I kind of find really amazing is that we have notaries that do this and they've had 3 or 4 commissions, and they should know better. That's right. We don't have any understanding of that. We generally, if we find out that they filled out a false certificate, no matter what the circumstances are, they will be revoked and fined for that. So
Sandra, I have a question, going back to the very beginning of certificates and correcting them. Right. And so it's kind of a fine line and a gray area when it comes to signing agents versus a general notary. And the reason I say this is because when it comes to loan documents, the lender requires that all the loan documents be dated for the same exact day, notarizations and everything. And there's a hard line on that those cannot be changed. If they do, it causes funding conditions. It can cause everybody a lot of time, stress, and money. So I have a question. If you were to have, like, for instance, I know a notary that was did a signing, a refinance, had a grant deed that he had typed out both of the borrowers that were going to be at the signing. He did not notarize the certificate. He just pre-filled their names on the acknowledgement. When he got to the signing, he realized that one of the borrowers was not signing that grant deed. So he lined through and initialed that borrower's name. The county recorder's office kicked that grant deed back, and they requested that he gave them a new acknowledgement with just the person that was present. Even though he had followed California guidelines, lined through and initialed appropriately, they were not having it. He, in this instance, again, they just wanted him to provide another acknowledgement that had just that one borrower's name on it. Would this be allowed for him to do that, or would you say that he would have to go back and re-notarize the entire thing?
So in other words, what they're asking him to do is just correct the certificate, giving them a new certificate and basically putting the old date on it. That's, yeah, no, that would be filling out a false certificate, because if you're filling it out at a later date and the person's not in front of you, then yeah, unfortunately that would not be allowed. Yeah, so I know that people do it often, and in most cases they probably aren't going to get caught. I mean, especially if the entity is the receiving entity is requesting it that way. You know, if we don't know about it, it's, you know, generally not going to come across our area unless there's any kind of complaint filed. But again, if at some point later down the road and there's a complaint filed against the notary for something, and during the investigation we find out that they backdated a certificate, then that's going to cause issues for the notary. So I know it's a hassle, but I think that to be on the safe side and to protect the notary, that it really needs to be redone.
Okay.
I know we had to do that when my husband and I bought our house a couple of years ago. One of the deeds had to be redone because there was a delay in closing of escrow on the buyer side of the house we were selling. And so we had to go back in and re-sign everything. And so it was a hassle, but I think legally it's better to do that than put yourself in a situation where you can be held liable for something like that. Does that help?
Yeah.
Does that help? I know it's not what you wanted to hear, but you know, like I said, notary law is pretty cut and dry on some of those types of issues, the backdating, the false certificates, the IDs, and those are yeah, something that I definitely would not chance.
Do you think that there's ever going to be the possibility of having similar but different guidelines for notaries and signing agents? Because when it comes to an actual loan signing agent, there's a lot of gray areas. For example, for that exact area is that if a notary is pushed hard enough by a lender to correct that certificate, or to fix their mistake, because generally it's the notary's mistake. It's not the borrowers or anything else. The notary was present. The borrowers were present. They saw them sign the whole bit, but then you sent in your acknowledgement and you forgot to stamp it, but it went FedEx and it's 2 days later now, and the lender's telling you, if you don't send in an original with the stamp, again, with the date and everything, we are going to sue your E&O. We are going to sue you for a rate lock extension, and you will be responsible. And if these borrowers lose their home, you'll be responsible for that as well. So I'm just curious, like, I don't want to be a lobbyist for notaries, but in the same respect, I'm very curious if there's ever been any kind of consideration or talk of if somebody is a general notary versus an actual certified loan signing agent, if there could potentially be a difference in some of the, laws or gray areas.
Yeah, see, the loan signing agents, that is a gray area, because we're looking at the notarial law. And so loan signing agents kind of fall under a little bit different. And, you know, I don't know, that's something that I can definitely talk with my manager about and see what thoughts he might have on it. And, you know, maybe get back to you. I can send Laura a note and she can forward it out to everybody. But I mean, it is something I think
great.
that has come up before. And I don't think there's ever really been any resolution to it. And I know occasionally, on occasion, our office, the Secretary of State's office, has forwarded specific recommendations for law changes and stuff to the Capitol building, you know, and whoever the representative that might take it up. And, you know, so that's something that I can forward on and see if I can get a little more information on, and then get back to you, because that is
That'd be
definitely a
great,
gray,
because
that
we
is
have,
definitely a gray area. So
And
let
every
me,
single person in this Zoom meeting right now is a certified loan signing agent.
okay, good.
yeah.
Okay.
And, you know, we've got a purchase, the signer's already living there, they've already moved in, and then a couple weeks later, we find out we made an error. And then the county recorder's office tells us we have to send in a new acknowledgement that matches the first one exactly, but maybe the name was, you know, not completely clear, or maybe the stamp wasn't completely clear. And the only way to do that is to send in a acknowledgement that matches exactly, because if we don't, then they have to unfund the loan. The signer's already living in the house. I mean, it's really, really
Yeah.
convoluted with some of these.
Okay. Yeah, I think that I have heard this come up before.
That'd be great.
So
if
we're
there was
talking
just
about
some sort of
mostly like a deed is part of the package that needs to be corrected, and the
deeds,
county's
grant
just asking.
deeds. They
Yeah,
just want something corrected on the actual cert, not that we missed any signatures or dates, but maybe the stamp's not clear, or maybe the name's not clearly written, or maybe
Okay.
the stamp is outside the margin. It's something that we did on our notarial cert only. We don't have to bother any borrowers or signers, but they just want a clear copy of another notarial cert for us to send in again so that they can
Okay.
fund.
Okay. Well, I have
That
one
would be
thing on my
great.
list to research and get back to you guys on.
Okay, thank you. All right, so should we open it up for questions now? I'm sure you guys have some questions. Raise your hand in your little screen.
I do.
Okay, go ahead, Sandra.
It looks like we've skipped number 4, or did I just?
Oh, did we?
The out-of-state acknowledgements?
Oh, we did. I'm sorry. Go ahead. Out-of-state acknowledgements. Do we have to line through capacity for out-of-state acknowledgements, or is this for California certs only?
Okay, again, on this question, I think it's really going to depend on the receiving agency. There is a statute that talks about filling out out-of-state acknowledgements, and they can do so as long as they're not certifying to certain things they're not allowed to. Usually what I recommend to people is that let me start over. What I see a lot is notaries, at least documents that come through our office that are going to other states, maybe and they come through for authentication, is you'll have a document and they'll have a pre-printed certificate on the form. It's not according to California statute. So we have notaries that will fill that out and then attach an actual California acknowledgement or jurat to the back of it. And, you know, my recommendation to them is that they should not be filling that out if they're certifying to things they can't certify to. I tell them, draw a line through it, just fill out the attached acknowledgement. So that's what they should be doing. Now, again, I think this is probably one of those gray areas as well, where depending on where it's going, if it's going to be filed in a county clerk's office in another state and not California, it's probably okay to fill it out, but you just you can't certify to the capacity of somebody. So you're just notarizing the name and the signature basically. So yeah, I would say, yeah, as far as lining through it, it really, like, again, it
Always
really
line through
depends on the,
capacity.
yeah, it really depends on the receiving entity if they're going to accept a document that has something lined through it. Again, like you said, the county would, you would
Okay.
line through some things and the county would reject it because it didn't match.
Mhm.
So again, that's just, it is going to
Mhm.
depend on where the receiving entity is and what they're going to accept if you line something out.
So even on capacity, so we could leave it if it's going to another state. So we have a few East Coast states that do require capacity stay on the certificate. So
Mhm.
that's been a battle too, because
Okay,
we typically line through an initial because we can't certify.
right. And so what are they
So
rejecting
they
the
want us to
document
redo our
or?
certificates and leave the capacity in there. They're rejecting the certs that we send over because we're lining through capacity.
And that generally doesn't happen in California since it's already in our handbook. We can prove that we're not supposed to be certifying capacity. But
Right.
when we're dealing with loan documents from other states, we are notarizing in the state of California. So we're following California notarial laws. But then you get, another state that says, oh, no, 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 no,
Mhm.
we can have capacity in ours and you have to do capacity. But it's kind of a mind game for, a California notary because we're like, oh no, we're not allowed to do that.
Mhm.
Right,
And then it causes a battle.
right. Well, I would say that you guys are right in what you're doing. Is there any reason why are they having? I mean, is this mostly because of property or?
Yeah.
I'm not sure. It's whatever they require in their certs for that state. So it doesn't happen very often, but every now and then this pops up.
Okay. Well, I guess all I can say is that you guys are doing it correctly because you can't certify to capacity, and the receiving entity is, if you're letting them know you're a California notary, this is California law and you're notarizing it in California, you can't certify to capacity. Then I don't know, maybe they need to get someone to notarize it that's in that state. I'm not sure, if they
Mhm.
want it filled out and that's allowed in that state, then I guess I'm just not sure why they can't have it notarized in that state. But, I don't know all the specifics on why they would be why you would be notarizing it. So.
No, that's good though. You're supporting exactly what Laura and I teach all of our students. I'm very happy and I hope all the Notary Academy students are happy to learn today that the information that we have trained is pretty spot on. And you're confirming that for us. So this is really fantastic.
Okay, good.
Okay, so Ralph, go ahead and ask your question.
Thanks for the info again. It's really, really helpful. Just had a question. I was on last week's call with I believe, Dr. Weber regarding Ron. Is that something that your division sees as moving forward, or is that still preliminary? Because it seems like she was more in the macro aspect of the micro aspects of it.
And you're talking about remote online
Yes.
notarization, right? Yeah. Okay. I was not on that call. I think I was actually off that day, but I did kind of get an update from the manager on that. And I know that's something that they really do want to move towards. It's been talked about for a number of years, but honestly, I really don't know yet at this point how serious they're looking at it. I think they're just gathering information now. They're also contacting some of the other states that do allow it to see how they've implemented it. And all I can tell you is what I would just check back periodically and find out where they're at on that. I wouldn't expect that it would go into place, at least not this year, and it might not be next year, but I just don't know for sure. But I know they're looking at it and trying to do some research and see how fast it's something that can be done. So I guess short answer would be they are taking it seriously, but I don't know how far along in the process they are yet.
Okay, because there was a representative from Montana, I believe, the Secretary of State from there, and their volume is probably not anywhere near what California is. So I
Right.
we could have had someone from a larger state, present and at least give apples to apples comparison. So
Yeah. No, and that's true. And that's something that we find some of the states, the smaller populated states, their implementation and how they do it is going to be quite different from California because of the fact that, population is so high here, and we have many more notaries here than you would in another state. So so that is something too that is going to factor into it as to how quickly they can get it done.
And my understanding too for California is that if we do enact RON, that it will not be enacted for real property. It will be for general notary work, but for real property, they would still require in-person thumbprints in the journal. Is that something that you've heard?
I haven't heard that, but it is quite possible, because that is something where, at least working in a compliance unit, that we see a lot of fraudulent certificates filled out for grant deeds. And so that might be the exception. I just don't know yet. I haven't heard if that's something that they're going to exclude yet or not. So
Good to know.
Okay, Patricia?
Hi, thank you so much for taking the time to meet with us today.
sure.
I going back to the journal, I had at one point sent in a question about using there's some new journals now that have 1 page per signer or per couple. And I was told that we couldn't use those, but based on what I heard today, I was just wondering, can I share my screen just to show you? Let me see if I can do that. Oh, okay. I'm not able to do that, but it's basically 1 page, and it has a list of all the documents on there. It has whether they're acknowledgement or direct. In other words, it complies with all of the things that California requires of each notarial act, but the signers are signing once, they're thumbprinting once on 1 page, so that later on, if a line entry was requested, you would submit the entire page. That's what those journals look like. And I would show you, but I'm not able to share that right here.
Yeah, I think if it's possible, maybe you could get me a copy of what you're looking at. Maybe have Laura send it to me. She's got my email. I can take a look at it and then maybe comment further.
Okay.
It's along the lines of the modern journal. It's not much different, but instead of a whole line, each signer has a page on one side.
Okay.
Yeah.
So you've got 2 people signing. Say you have a couple buying a house, and they're going to be signing their name on all the documents, and
Right.
their signatures are going to be on every document. So so you're saying that for those, you would have 2 separate journal entries?
So it would, if it's a couple, there's actually room on 1 page for 2 people. So that would be,
Okay.
if it were just 1 person, then they would get their own page. Because I do a lot of trust signings also.
Right.
So, and then I like the journal also because it really helps with privacy, because each person just gets the 1 page,
Right.
and
Right.
it's several documents listed on that page. It has a signature, a thumbprint, but I only capture their signature and thumbprint once. The documents are listed each, the date of the document, the fee, whether it's an acknowledgement or jurat, all of that is listed there.
Okay.
But I would only capture the signature and thumbprint once.
For each person though, right?
Each person, yes.
Yeah.
Each person.
Okay.
Tricia,
I mean,
do you
that
have a
sounds
blank
like it.
copy you can just hold up to the screen to show her? Do you have the journal right
No,
there?
I have it. I didn't purchase it. I just have a PDF
Sorry.
of it. Yeah.
Yeah, if you could please maybe send that to Laura, and then she can forward it to me, and I'll take a look at it.
Okay.
It sounds like from what you're describing that would be okay, but I'd rather take a look at it and just to be certain. So
Okay, I understand. All right. Thank you.
Vicky?
Oh, she got on
Can't hear
here.
you yet. Yeah. Here, let me see if I can. Oh, there we
There
go.
you go.
Okay, thank you. Thanks for taking my question. Okay,
Mhm.
this is a general notary question and it comes up quite often. It's the AKA.
Mhm.
So I also wrote my question in the chat bar. So let's say I have a signer, his ID says Tom Smith. But on the line of the document, it says Theodore L. Smith. And he does not have a secondary ID saying Theodore L. Smith or just Theodore Smith.
Mhm.
And he doesn't mind marking up the documents, like striking through anything and rewriting or initialing. But let's just say the signature line says Tom Smith. Oh no, says the opposite, Theodore L.
Theodore.
Smith, also known as Tom Smith, but Tom Smith is the only ID I have.
Yeah, unless they have a second type of ID, like we talked about earlier, maybe some kind of a certificate or,
Yeah, it doesn't have anything, nothing.
yeah, if there's no secondary that shows that they're known as both, then that's probably not something I would,
Okay, so if it was the opposite, it's okay. If it's Tom Smith, also known as Theodore L. Smith, because I have the Tom Smith ID.
correct. Uh-huh. Yeah,
Okay,
you would be notarizing it according to what the ID says.
okay,
So if he signs the document as Tom Smith, AKA Theodore Smith,
that's okay.
that's okay, but you want to just make sure the ID that you're accepting has, that name is included on the document, and that's the name that you would put in your journal as well.
Right, the Tom
Yep.
Smith.
Mhm.
Okay. Okay, so also, what if the signature line, underneath the signature line, it said the opposite, like I was saying, the Theodore L. Smith, also known as Tom Smith. Could he just sign his name and then comma Tom Smith? Or the signature line underneath has to be printed exactly Tom Smith?
Vicki, I think that might be a lender question, because if you're gonna change the name on docs, you need to go to the lender first and make sure that's okay.
Well, this is a general notary question. And the
Oh.
attorney said it's okay to do it what you want, so.
Okay, well, my suggestion on that would be, again, you would need to talk to the receiving agency
Mhm.
Okay,
and see if they're okay with that, because
Okay.
again, you're making changes to the document and that might not be okay with them. So, so that's what I
Okay.
would suggest for
Mhm.
that. Yeah, it's really, if they're signing a certain way, AKA something else, and you have, proper identification that you feel comfortable accepting for that, that's okay. And that's how you note it in your journal. But if you're making actual changes to the document where you're changing a printed name or something, then you're definitely going to want to see if that's a problem for the receiving entity.
okay, so I can
Might
put,
reject it. Yeah.
I can put on, okay, let's say I kept everything the way it is. I can put on my certificate, the Tom Smith. And I could leave on the signature line, the AKA Theodore L. Smith, right? I don't have to cross that out because I'm not certifying, I'm only certifying him as Tom Smith, not,
Right. If
It's
he signed
AK.
Tom, if he signed Tom Smith, AKA Theodore Smith, his ID says Tom Smith. That's how you identified him, and you put that in your journal. I mean, that would be okay on your part. Again, it depends on the receiving entity and if they're going to accept that or not.
okay. Now, how about if he has an ID for both of those names? Am I allowed to put an AKA on the certificate, my certificate?
You can, yes.
Okay. All right, thank you.
Kelly?
Hi, thank you, Sandra.
Sure.
This is a journal question. So
Okay.
I'm also using Notary Gadget and to record fees. And I was told, I can't remember where exactly, to write 0 in the journal for the loan signing so that it doesn't look like you're double charging, and that could be confusing.
Right.
But after listening to today's conversation, I'm not sure that that's correct. Could you let me know what you'd be looking for?
Okay, so what you're saying is you are doing notarizations for a package of loan documents. You put it in your journal, and you've been putting in 0 because you're not actually collecting money from the person you're notarizing. You're
Mhm.
getting paid by the lending
Mhm.
company, correct? Okay. I would say that in this particular case, a 0 would be appropriate, because when you do the notarization, you're not collecting from the person you're notarizing from. In other
That's a
words,
great
you're not.
question, Kelly.
Yeah. So in this case, I would put 0. And if you wanted to notate in your journal that, you know, your payment comes from as part of your job, basically it would be considered you're the employee, you're getting paid to do the notarizations, and you're not charging them a fee for the notarization directly.
I would like to comment on this. Yes, I do it the same way, Sandra. I do 0, Kelly. I don't put a fee in there for that exact reason. In my notes, you guys, I always list who gave me the signing. If it was the escrow company, I list who the escrow company is and who the escrow officer is. Or if it was the mortgage company, same thing. So just like Sandra's saying, that right there in your additional notes, it's showing who you're being paid by.
Yeah,
Okay.
that's perfect. That would
Thank
That's
you.
awesome.
That's-
Okay.
Thank you.
clear it up. Yes.
And just before I go, just to clarify, Kimberly, maybe the question you had about when we were talking with Sandra about making corrections, notarial corrections on the certificate, and the county kicks it back for some reason, and or you might get sued, they, you know, for not getting it to them in time. Was your question that the date wouldn't match the original document, and that was the challenge in recreating it? I was unclear on what the challenge was there.
Well, really, technically, Sandra is telling us that when there's a correction like that and they're requiring that, notarial law says that we are to provide a new certificate with a brand new date. Well, you're not allowed to, you know, backdate or provide another certificate. So that's why I was asking Sandra if we can maybe try to see if signing agents have a different kind of area when it comes to that, because it does make it very challenging compared to general notary work. So hopefully we'll get some answers, you know, in the future for that.
So the challenge was that it would have a new date that wouldn't now match that original one and the original deed, and that's the challenge, correct?
Yes.
I'm going to follow up on your research you were going to do, I think, Sandra, on that. So thank you, Kimberly. Okay, I'm done.
Samantha?
If I can find the unmute. Hi, guys.
Hi.
I would like to know how we can get a representative on the board, whoever makes the laws, not only the notarial law, but also the exam. How can we have a word in what type of laws go into effect and what kind of questions are on the exam?
Well, that would probably be something that would have to go through our manager for the notary section, our manager 2, our top manager in that particular section. So if there's anything that you would like to see, maybe on the exam, or any different types of, you know, potential law changes for notaries, it would really be something that you would have to put in writing. Basically what it is that you would like to see and why. And then it would go to our manager, and they would review it, and then it would have to go be reviewed with our division chief. And then we have in our executive office, we have a legislative, I don't know what they're actually calling it now, but they handle all of the legislative changes and different things that go on. Anything that goes on at the Capitol that will affect our office and vice versa. They have connections over their representatives that they can talk to. So I think the first step for something like that is definitely to put it in writing with as much detail as you can. And then you would send it to us. And I can give you our manager's name. That's who you would send it to as far as whose attention. And then then that would start the process of at least reviewing it and seeing if it's something that's doable and that we could get through the legislature to change. And then of course the testing company, that works a little bit different. Again, I would say you would put it in writing again, it would go to our manager. And we do have periodic reviews with CPS, our testing company, on questions. Every so often, they'll send us some questions to review, make comments on. Maybe there's certain test questions that aren't performing very well. Maybe we need to do a rewrite of it or something. And that any changes to the testing questions can be done during those review times. And usually that's once or twice a year that we do those. So for both cases, a legislative change or an exam type of change, question change, it would still need to be put in writing, sent to our manager, and then it reviewed and then dispersed out from there. So it would either go to our legislative office or it would go through our review with the testing company.
And can I have that name that we would address
Sure.
that to?
Sure. So our division or our manager is, he's our, I guess, manager level 2. He's the head person for the notary section. That his name is William Downs, D-O-W-N-S.
Thank you. And we bring that up only because the exam, we're really noticing, I know it's heavy on misdemeanor versus felony, you know, the fine amounts, but it's not heavy on practical everyday. What do we do? Does the notary know how to do their job? And that's really what we'd like to see hopefully start changing, is that, do you actually know how to fill out a certificate? Do you know what a real certificate looks like, or a proper certificate? So I'd love to write something to that extent.
Yeah, they did a job analysis study about, I want to say it was probably about 5 years ago. And the testing company was the one that facilitated it, but they contacted just randomly some notaries throughout the state and asked of them if they wanted to participate. And then they also had a couple of us, what they call subject matter experts from Secretary of State. I was on that panel at the time. And they did just a huge job analysis review of all the different functions of a duty, of the duties of a notary. And they kind of revamped the test a little bit, and it changed a few years ago. And I think one of the issues that came out of that job analysis was there was a lot of misconduct issues that came out, and what the notaries are liable for and what can happen to them. And so it's kind of evolved a little bit. And every year when we do one of these exam question reviews, we've actually pulled a few of those questions out because they were so heavy on a certain area. And I seem to think as they continue to do these, some of those will come out and they'll probably add a few new questions, but it does take a little bit of time. So, you know, you're still welcome to put that in writing, and then that's something that we can actually present to Bill and to our testing company, and go from there and see if some of those can't get pulled and rewritten faster or not. I just don't know, but that's kind of how it works when we're working on the exam items. Is they're reviewed by both notaries in the field and folks here that work at Secretary of State. And then they put a value to the question, how often is this coming up? If it's not coming off very often, it's probably not something that should get asked very often on tests. And then the more common stuff. So that's kind of an ongoing thing that they do. So I'm going to note that though, because I have to find out when the next review is going to happen. And then depending on whether I'm still here or not, I'll have to maybe make a suggestion for either Amy or Jamie to be on that, in that group for that review. So, but I'll note it. Yeah.
Appreciate it.
Okay, Jennifer.
Hi, thank you for taking my question. This is General Notary. I have a question because I've gotten a couple of different answers recently On Mylar parcel map signings, we are unable to attach our seal to the Mylar. Does the Secretary of State office require a loose certificate to go along with the Mylar for a Mylar signing?
Okay, I'm a little unclear. What is a Mylar again? I'm sorry, I haven't heard
Okay,
that term.
Parcel maps come on Mylar, like a Mylar balloon. It's a sheet of Mylar paper,
Uh-huh.
and you cannot put your stamp on it. There's a special pen that's used with this. So I'm not able to stamp this certificate. It's printed directly on Mylar.
Mm-hmm.
So I have been issuing a separate certificate with it, with the stamp. And I have been unable to find anybody that seems to give or know an answer to that. If you are required to do a loose certificate
Yeah.
along with the Mylar parcel map.
Yeah, that sounds like what you're describing as a subdivision map. And those, I believe in statute, say you don't have to use a seal for those.
I remember
they
that
don't.
one.
And it's one of those things that comes up not very often.
It's on the test though.
Yeah, it is on the test.
Stamp's not required.
Yeah, there's that one exception. I'd have to look through my handbook to get the
I believe
exact
that is
code.
the one and only notarial act where it's not required because of the Mylar.
Yep.
Yeah, let me
You do need to look up the statute though, because there are specific things that you need to print next to or below your signature. You need to print your name, your commission ID number.
Address, commission, expiration. Yeah, that's all printed out on the Mylar itself. My question was just the loose certificate.
Okay, yeah, I'm looking at it right now. Let me see. Yeah, it says a law. Hold on. The law allows a limited exception when a notary public may authenticate an official act without using an official notary seal, which is a subdivision map. They're usually drawn on a material that will not accept standard stamp pad ink. So in that case, you can't use the seal, but the notary public's name, county of the notary public's principal place of business, commission expiration date must be typed or printed below. Next, adjacent to the notary's public signature. So that looks like it's government code section 66436C. I'm just gonna pull that up and make sure that matches. So basically, instead of stamping your seal, you're going to be writing some of the information from your seal on the map with that special ink. Yeah.
Thank you. Yeah, I had one customer insist that they needed an additional certificate with it, and I told them I didn't think so, and I just did without. And I told them they could come back to me and I'd redo it if that was the requirement, but it was my understanding that the certificate was not needed. So thank you.
Right. Yeah. Yeah. I was just trying to make sure that was the right code section, but yeah, I can send Laura the specific code section for that. But yeah, if they come back and tell you that they need the seal on it, that's not something you're going to be able to do, not on that type of. And I believe that is the only exception, at least right now, is the subdivision map. So instead of stamping your seal, you would just put the basic information from your seal with that particular special ink and just do it according to what the statute says, what is minimum, what has to be there. So I'm going to look that up and send that to you.
All right, so we have time for maybe 2 more questions. Brandy and then Linda, and then I think we'll wrap it up because I'm sure Sandra has other things to do today. But these are all amazing questions, you guys. So go ahead, Brandy.
Okay, so back to the journal, and I know might be a gray area, but if we do discuss that you are okay accepting for the signers, sorry, for the, like, let's say modern journal, timestamp, I've always been told I've done 1 line per certificate, and I've always put in a timestamp that I've stamped in front of the signer. And so that could, let's say a signing takes 1 hour, that's chronologically how it has been noted in my journal. So if we do one stamp, or excuse me, one line with multiple entries, then we can just put the timestamp as the time that we met with them. Do you care about the timestamps that much when you're doing, journal checks?
Well, yeah, when we're doing journal audits, that is one of the requirements, is that it has the date and time. So, it only really requires one time. So in that
Okay.
particular case, I would probably just put basically the time you started,
Okay.
and that would be sufficient for that. Yeah.
Okay.
Great.
And then just one other quick question is, do you ever find a problem with, let's say for general notary work on a power of attorney, us acting as a witness while also notarizing?
On a power of attorney?
So in
Yeah, I
other
believe
words,
it's-
can we witness if we're notarizing as well?
Exactly. Yeah.
The general rule for that is no.
Okay.
If it's a separate document that you're not notarizing, that you're acting as a witness for, that's okay.
Okay.
But if you're notarizing and being a witness for the same document, no, you don't want to do that. So,
Okay.
and that we have had a few cases of that. So like, I'll just give you a quick example. A lot of times, like when people are doing trust packages,
Mhm.
I know when my husband and I did put ours together a few years back, the notary that came and notarized the different documents signed as a witness on the actual will, because the will was not being notarized. It was just like the other stuff, the power of attorney for health care and all that stuff. So that was fine, because she notarized these other 2 or 3 documents, and then the will itself was not notarized, but she signed as a witness that she saw us sign it. And that
Okay.
document was not notarized. So that is okay. But if it's the same document and you're notarizing, you don't also want to be a witness on that document.
Okay.
Can't be
And
both.
let's say that we have done that. Is this something that would come back, if they were held up in court, that witness wouldn't, do you go correct that, or would you say it shouldn't be a problem?
I guess it would really depend on the case and what the document
Mhm.
was, and if it came up in court and that became an issue. If you've done it in the past, usually if that would be something where we would probably just do an admonishment letter and say, hey, you're really not supposed to do that. Please not do that in the future.
Mhm.
I don't think that that's something that you would actually, be revoked or fined for. No.
Sandra, I thought it was our understanding from when we've read the codes, the primer, that legally you can witness, but it's just not best practice because there's a lot of liability.
Right. No, that is correct.
Okay,
That is correct.
just
I don't
making
think
sure.
that there's a specific code section,
Okay.
that says that. It is really best practices. Just
So don't do that ever again.
Just don't do it. It's not best practice.
right.
Yeah.
And I guess what I should say is that I don't think there's a provision in law that states you can't do it.
Mhm.
But best practices, yes, it's probably not something that you should be doing, because later on down the road, it could cause problems.
Mhm.
If a will or any kind of a trust type document is contested, any kind of document basically is contested in court for some reason, and that comes up, that could be an issue, and the notary could be held liable for part of that.
Mhm.
So it's just kind of a matter of just protecting yourself and not serving as a witness on the same document that you notarize. Yeah.
Thank you so much.
Linda?
Hi, everyone. I have a quick question here. On the journal, it has date of document. Some of the loan documents, they don't have any date. Is it okay to leave that section empty, or that area empty, or just put no date? Or
I don't believe that the code says that's a required item. So it requests that you have the date, time, and type of the act. So that would be the date you're notarizing, the time, and what you're the type, which is the acknowledgement or jurat. The
I have
character
the
of the,
modern journal, so the modern journal has that's what it
Okay.
is, yeah.
okay, and then the character of the document, meaning what it is, grant deed, whatever it is. The signature, the ID information, the fee charged. So the date of the document itself is not a required item in the journal. So if there is no date on the document for you to use, then it would be acceptable for you to leave that blank.
Good,
And
thank you.
that's not something, when we're doing an audit of a journal and those are left blank, that's not something that we're going to include in our audit because it's
Okay.
not required per the code. So,
Okay. And also on the fees, so you say it's okay to enter 0 under the
Mhm.
fees for our notarial acts. But I was told that our notarial acts are not taxed. So that's why it was okay to enter $15 per signature. So I'm trying to.
I think that's a whole other question. That's a CPA question.
Okay.
Yeah, we can help you with that one.
Okay. So.
And then Stuart, do you have a quick question? I know you've been waiting.
Yes, I do. Just following up actually on a question that Mary Ann G asked. When we're putting in the document name in the journal, some of these documents have like really long names. Is it okay to abbreviate the name of the document?
I think so, as long as we're able to tell what it is. Sometimes I've seen things in there where they have all these acronyms. I've never heard of them before. So in that case, it's like, well, I don't even know what type of document this is. And that's where you run into problems. But if you can abbreviate, but we're still able to tell what the document is by the abbreviation, then it should be fine. Yeah.
Great
Like
question,
a lot of times
Stuart.
I'll see GD there, and I know that's a grant deed. So, but I know there's other documents that, yeah, there's just really long names. If there's no way to abbreviate it, then you're just going to have to write the whole thing in there, if as best you can. But if you can abbreviate and still make it clear what it is, then that's okay.
Great. All right, I think we're going to wrap this up. Sandra, thank you so much. This has been amazing. I think everyone can agree this has been very eye-opening, and you've answered all the questions that we had. There's just so much gray area. We're so grateful that you're here.
Oh, no worries. I was happy to help. It was a kind of a learning experience for me too. So, and I just hope the information that I was able to provide helped. And I do want to just kind of quickly just maybe review the things that I need to get back to you on. You wanted information on the loan signing rules, if they're a little bit different than for corrections.
Maybe some
than for
exceptions.
notary, right?
Yeah. Yes,
Okay.
for sure.
And then there was one of the folks there that was going to send a PDF copy of a journal for me to review and just get back to you on. So I had those two things. Was there anything? Oh, and I was going to check and see when the next review is for the exam questions. So,
okay.
So I had those three things on my list. Was there anything else that I missed?
I don't think so, but I could email you if something else pops up, or you had any questions, or the students had any questions. I think you were very thorough. So okay, I think most of our questions were answered.
Okay.
This was fantastic. Thank you so very much.
Oh, you're welcome. You're welcome. And then I'll be in touch on these other items, and then I'll just send it to Laura, and then she can forward it out to everybody. And then if there's any follow-ups or anything, definitely let me know. So
I'll do. All right. Thanks everyone for coming. Thank you, Sandra.
Right. You're welcome. Thank you. Thanks for having me.
Thank you, everyone.
All right. Bye.